For more than 50 years, we had in place what was called the Wire Act. The Wire Act had a prohibition on gambling. It's why you couldn't go down to your local bookie or go down to Western Union, start wiring money and betting on who knows what. That was in place until Christmas Eve, the day before Christmas Eve in 2011. And with no input from the public or notice to Congress, a single unelected lawyer in the Office of Legal Counsel, the Department of Justice, released a 13-page memo reversing 50 years of Department of Justice precedent and an understanding that Congress had that the Wire Act was in place to prohibit the use of wires to engage in gambling. The memo that was introduced declared that the Federal Wire Act applied only to sports betting and not to all forms of betting. This reverses what the Clinton administration, the Bush administration, the Carter administration, and others had interpreted. Now, certainly with the growth and the expansion and difference of the Internet is making on all of our lives, there was this interpretation that didn't come through Congress. It didn't get the proper vetting. There was not the recourse. The point that I've made in sponsoring a piece of legislation that would take us back to Restoring America's Wire Act is that if you want to see a change, if you like a different public policy, if you want to see things done differently, our framers have put forward a process, and that is you introduce a bill, you fight for it, and you try to get it passed into law, passed through the House, passed through the Senate, and signed by the President of the United States. We don't simply make up laws by one attorney at the Department of Justice down in the bowels there at the Department of Justice. We don't erase laws. We shouldn't be creating laws. That's the whole point of this piece of legislation that I had. Nevertheless, with this OLC opinion in place, it has created quite a stir, a lot of confusion, and potentially an awful lot of problems. The reversal that the OLC put forward was contrary to a plain reading of the statute, the intent of Congress in passing the law, and the longstanding position of the Criminal Division at the Justice Department. And the result is now anything connected to the Internet, desktops, laptops, tablets, smartphones, no matter your age, potentially becoming a casino. I got a problem with that. The OLC basically just decided, based on the placement, literally, of a single comma, that the law didn't mean what everybody thought it meant for more than 50 years.
So I have an interest in this because in 2001, the United States Virgin Islands passed the Internet Gaming and Internet Gambling Act. And over the past decade, the government of the Virgin Islands has really been handcuffed by incorrect interpretations, they believe, of the Wire Act. And I believe that if the Act was allowed to be implemented and regulated properly, much needed revenue might be brought to many different states that have this law in its place. So I was really interested in a much more historical look back on how this came about. I've worked at the Department of Justice, worked in the Deputy Attorney General's office, and understand how long it takes for an opinion to come out of legal counsel, the Department of Legal Counsel. So the idea that this was drafted and written and signed in the middle of the night, to me, is somewhat a difficult stretch of my imagination, knowing the inner workings of the Justice Department and how long it takes for an opinion to come out. So I wanted to look at the interaction between the Justice Department and Congress over the many years in which before that opinion was drafted. So Mr. Klein, I understand that in 2002 there was a case called In Re MasterCard in which the Fifth Circuit Appellate Court ruled that the Wire Act applied only to online sporting betting. Is that correct?
That's my understanding.
Okay, that's your understanding. And that the Fifth Court made that decision, that would have been 9 years before the Department of Justice's legal opinion, correct?
That's also what my...
Okay, and since then, during that time, 2009, even before that, Congress has weighed in pretty consistently on this issue up until now, that there seems to be some question about it. So, Mr. Wilson, were you aware that between 1996 and 2006, Congress passed a series of bills to update the Wire Act and made it clear that the act should not apply to online casino operators duly licensed by a state to offer casino games to people located in those states.
Into which, I'm sorry, which states?
To any state.
To any
This was an
state,
act passed by Congress.
No, I'm not.
Okay, and were you aware that Representative Goodlatte in the 106th, 107th, 108th, 109th Congress offered legislation on this matter? Senator John Kyle, Representative Leach as well?
No.
Okay, and that even though none of these laws was enacted, the passage of those bills in both congressional houses gave a clear evidence that I would think that there is congressional intent on this matter. So in 2006, Congress enacted the only law that deals directly with internet gaming. Are all of the witnesses, are you familiar with the Unlawful Internet Gambling Enforcement Act, otherwise known as UIGEA? Are you all aware of that? I take that as a yes?
Yes.
Okay. I don't want to go into lawyer mode and, okay, thank you. So I'd ask that the record reflect that all of the witnesses says that they're aware of that. And I have a slide that I'd like to show. Here's what UIGEA said, that the term unlawful internet gambling does not include placing, receiving, or otherwise transmitting a bet or wager where a bet or wager is initiated or received or otherwise made exclusively within a single state. And then it goes on to say the bet or wager and the method by which the bet or wager is initiated and received or otherwise made is expressly authorized by and placed in accordance with the laws of such state. And finally, and the state law or regulations include age and location verification requirements reasonably designed to block access to minors and persons located out of such state and appropriate data security standards to prevent unauthorized access by any person whose age and current location has not been verified in accordance with such state laws or regulations. Mr. Liparelli, is it clear to you from the reading of this law that Congress never intended to ban states from authorizing and regulating online gambling within their own borders?
The language debated in and around UIGEA was intense, and I believe you're correct that that was the intent.
The final intent and what the language of the law itself says.
If you want to see things done differently, our framers have put forward a process, and that is you introduce a bill, you fight for it, and you try to get it passed into law, passed through the House, passed through the Senate, and signed by the President of the United States. We don't want to erase laws.
So this legislation, which was passed incidentally in a Republican-controlled Congress and signed into law by President Bush, this precise language of UIGEA is what the Department of Justice Office of Legal Counsel utilized in determining that it was needed to update DOJ's position to conform with Congress and with the courts.
I believe that's correct.